Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast. I'm your host, Spencer Karen. On Monday, the Supreme Court released its decision in the United States Agency for International Development versus Alliance for Open Society International. By a vote of 5-3, the judgment of the U.S. Court of Appeals for the Second Circuit is reversed. The justices held that the enforcement of a law requiring foreign affiliates of domestic groups receiving funds to fight HIV/AIDS to have a policy opposing prostitution and sex trafficking does not violate the First Amendment. Justice Kavanaugh's majority opinion was joined by the Chief Justice and Justices Thomas, Alito, and Gorsuch. Justice Thomas also filed a concurring opinion. Justice Breyer dissented, joined by Justices Ginsburg and Sotomayor. Justice Kagan took no part in the consideration or decision of the case. Our speakers will discuss the decision and its implications. And now, to discuss the case, we have Casey Mattox, Senior Fellow at the Charles Koch Institute, and Krystal B. Swendsboe, Associate at Wiley Rein LLP.
So this was billed and briefed as a compelled speech case. Whether the government can dictate speech by conditioning grant funding on the adoption of the government's anti-prostitution message. The speech requirement is part of the Leadership Act, which authorized over $80 billion to combat HIV/AIDS and requires that no funds may be used by an organization, quote, that does not have a policy explicitly opposing prostitution, end quote. This is the second time the case has been before the court. In 2013, the court ruled that the funding requirement violated the First Amendment because it required respondents, same respondents in this case, domestic grant recipients, to pledge allegiance to the government's policy. The same issue is presented here, whether the policy requirement was also unconstitutional because it applied to respondents and their speech through closely related foreign affiliates. Based on the record, the foreign affiliates are virtually indistinguishable from the domestic entities. They share branding, message, they speak with one voice. Even Justice Breyer talks about that in the dissent. Now, respondents before the court argued that the 2013 decision resolved this issue. Dictating the speech of closely foreign affiliates is the same as dictating speech for the domestic entities, and the policy requirement should be ruled unconstitutional. Now, the government, in opposition, drew a very fine distinction based on corporate formalities of the domestic and foreign entities. In fact, argued that there are no constitutional barriers or limits to dictating speech because we're dealing with foreign entities here. So, Casey, do you want to talk to us about the majority opinion?
Sure. First of all, this was a 5-4 decision written by Justice Kavanaugh and decided essentially on what people would, at least before the last couple of weeks, if it's still an accurate descriptor, would have thought of as kind of the conservative justices on one side and the more liberal justices on the other side. We've been disabused of the notion that is a good way to divide up Supreme Court justices for over the last 2 weeks, if not long before. But Justice Kavanaugh had the opinion for the court, and I'll just kind of work through basically what he says. Now, granted, this is a decision that this was argued back in May, decided now, and at least in my view, I think the analysis, for better or for worse, is rather simple in the opinion. That may reflect the fact that there's a limited amount of time. It's also, I thought, at least Justice Kavanaugh's majority opinion was a rather clear opinion. It attempted to set some sort of clear lines here. He begins first with, it's a long settled matter of American constitutional law that foreign citizens outside the United States territory do not possess rights under the U.S. Constitution. Plaintiffs do not dispute that fundamental principle. The dissent does dispute the fundamental principle, and Krystal will talk about that just a little bit, at least the breadth of the statement that he makes there. But he states that as just a known fact, that if you're outside the U.S., that foreign citizens outside the U.S. don't possess rights under the Constitution. Second, it's a long-settled principle that is a matter of law, American corporate law, that separately incorporated organizations are separate legal units with distinct legal rights and obligations. So those are two very kind of bedrock principles as he identifies them. And he says that those two bedrock principles of American constitutional law and American corporate law together lead to a simple conclusion. As foreign organizations operating abroad, plaintiffs' foreign affiliates possess no rights under the First Amendment. Now, keep in mind that there are no foreign organizations that are actually party to this case. The parties involved in this case are the domestic organization and USAID. And the argument is that for the domestic organization, requiring their closely identified foreign affiliate, so AOSI International as opposed to AOSI Domestic, or AOS, that requiring them, the foreign affiliate, to adopt this statement of belief as their own, that actually interferes with the domestic organization's free expression because the sort of misattribution of the message from the foreign organization to domestic. He goes on and says Congress can condition funding on a foreign organization's ideological commitments. This is a quote. For example, pro-democracy, pro-women's rights, anti-terrorism, pro-religious freedom, anti-sex trafficking, or the like. Kavanaugh continues and says, by contrast, plaintiff's approach is through a constitutional wrench into American foreign policy. Congress would be in the untenable position of either cutting off certain funding programs altogether or funding foreign organizations that may not align with U.S. values. I have concerns with the way that is framed because I think, first of all, it significantly overstates the case. Congress presently, even with domestic organizations that clearly have First Amendment rights and where those have been affirmed under the prior decision, Congress can say, for example, that you can't use appropriated funds in a program for purposes that would be contra the program. So, for example, there's another requirement for participating in this program that's not even been challenged, and that's that you can't use the funds to actually promote prostitution. And so AOSI says, well, we have no intention of actually promoting prostitution, so they're not actually promoting prostitution in the program, and no one disputes that. The question is really, well, can you require them to adopt their own formal policy, make it their own personal statement of the organization's own values as a consequence of being able to participate here, which raises the other question, what exactly is the harm-benefit calculus here? And that's frankly a question that's unanswered through the entire opinion. There's not much of a discussion about what exactly the federal government gains when it can already say that you can't use these funds in ways that the federal government instructs you not to use them. What does it gain additionally by saying that these organizations must believe what the federal government says you must believe in order to receive the funds? So requiring them to adopt their own personal policy that says that you reflect Congress's values. What exactly is the benefit of that to the federal government? And what is the harm of allowing an organization that's not otherwise doing things in violation of what Congress wants done to participate in the program? The United States is not forcing plaintiffs to affiliate with foreign organizations. Plaintiffs are free to choose whether to affiliate with foreign organizations and are free to disclaim agreement with the affiliate's required statement of policy. So essentially, one of the arguments here is, look, to the extent that Congress is placing any burden on these foreign organizations, or to the extent there is a burden placed on foreign organizations, on the domestic organizations, it's because the domestic organizations choose to affiliate with foreign organizations. So it's basically it's not our fault. We impose this rule on the foreign organizations. If people are misattributing the statements made by foreign organizations to domestic organizations, that was your choice to choose to affiliate with them, is the argument there. Plaintiffs emphasize that the court can narrowly decide to protect the free speech rights of only those foreign organizations that are closely identified with American organizations. And yet they didn't do so. But again, the First Amendment cases involving speech misattribution arose when the state forced one speaker to host another speech. No compulsion is present here. Krystal will get into a little bit kind of the the dissent's response to that, which I think needs to be taken pretty seriously, that the majority is glossing over ways that, in fact, the federal government can force that misattribution on parties, and the sort of unfortunate, well, the clarity of this opinion might actually gloss over some of those open questions still to come. And then he concludes, plaintiff's closely held distinction would enmesh the courts in difficult line drawing exercises. How closely identified is close enough, and leave courts without any principal basis for making those judgments. My view is that this concern ended up driving a lot of the analysis here. And this was a pretty significant burden, pretty significant problem, I guess, for AOSI. It's one thing to say that you want an exception for closely identified organizations where people would misattribute what the international organization is saying to the domestic organization. It's another thing altogether to try to identify when is the affiliation close enough for that to really be a problem. And I think that at least the majority of the court had a difficult time figuring out exactly how they would draw that line. It was much cleaner and easier to draw a line, as Justice Kavanaugh did at the beginning of the opinion, that says if you're a foreign organization, you do not have First Amendment rights, and you have separate corporate structures, then we can draw the line right there and not have to get into the difficult line drawing exercise. Krystal, you want to walk through the dissent?
You bet. So one quick clarification. This is a 5-3 decision because Justice Kagan was recused.
Sorry, right.
So on the dissent side, Justice Breyer wrote the opinion, and he was joined by Justices Ginsburg and Sotomayor. He very clearly states it at the beginning of the dissent. This is a case about First Amendment rights of American citizens, drawing a big distinction from the majority, who really focused on the foreign entities. The respondents in 2013 are the same as the respondents in this case. Give it, one or two might have dropped out, but we're talking about American citizens and American entities here. And so the case in 2013 should have decided the matter. Justice Breyer then goes through a lengthy discussion of the record in the 2013 opinion. I would bet to make up for the lack in Justice Kavanaugh's opinion, this could very well be faults that this opinion came at the end of the term. But also, I think it's helpful to go through all of the facts, the record, the discussion in 2013, which really was given short shrift in the majority opinion. Specifically, Justice Breyer notes that the dual structure solution, that is, there's a heavy distinction between a foreign and a domestic entity. This was proposed in 2013, and Justice Breyer points out was rejected by the court. Quote, because corporate formalities do nothing to ward off speech distortion where the government has required a speaker to espouse a specific belief as its own, end quote. So the dissent argues that respondents should have won this case for the same reasons they won in 2013. When respondents speak through legally separate but clearly identified affiliates, in this case, the record shows that they speak with one voice. In 2013, the court held that speech is attributed to respondents for First Amendment purposes. Exactly what the court should have held here, and I tend to agree. And then Justice Breyer had some excellent quotations. Audiences everywhere attribute speech based on whom they perceive to be speaking, not on corporate paperwork they will never see. The majority really relies on this idea of corporate formality and corporate distinction. Most people have no idea that these are separate entities at all. And then finally, I really appreciated this quotation from Justice Breyer that in the First Amendment context, the corporate veil is not an iron curtain. In fact, it's just the opposite, because we attribute speech across corporate lines all the time. So, and to kind of play off of something Casey had mentioned earlier, one of the few cases that the majority actually discusses in some detail is this Hurley case, which dealt with a parade throwers and a gay and lesbian message that was included in the parade. So the dissent goes through and rebuts the majority's claim that Hurley involved compulsion and is therefore very different from this case because AOSI there's no compulsion. However, that case was really about a combined kind of multifarious set of voices. You had multiple entities that were part of this parade, and it was simply adding one new voice to the mix. It's not a compelled message that's attributable to a single speaker. The real difference is that in Hurley, the parade throwers were required to host speech. And something Justice Breyer points out, the government requires in a number of different ways. However, they were not required to adopt a policy or profess a belief, which is, I believe, what the dissent would argue and what I would argue the policy requirement here does. So the consequence is, as far as Justice Breyer is aware, and frankly, as far as my knowledge goes, the court has never before held that an American speaker forfeits First Amendment protection when it speaks through foreign affiliates to reach audiences overseas. And then, of course, Justice Breyer goes on to address these bedrock principles raised by the majority. And those two principles are that foreign citizens do not enjoy constitutional rights, and then there's a distinct separation between, there's a corporate separation that must be respected. With respect to the first kind of bedrock principle that foreign citizens do not have constitutional rights, Justice Breyer calls this a sweeping assertion. It's neither relevant nor correct. This is a case about American citizens and the speech of U.S. entities. The statement and the fact that the statement that foreign citizens have never enjoyed constitutional protections is inaccurate. The court has studiously avoided establishing this absolute rule. And in fact, there are certain circumstances where foreign individuals in the United States or other circumstances have been granted constitutional rights. There's no need for the majority to make this statement because the respondents' argument agreed that the foreign affiliates acting on their own do not have First Amendment rights. Again, we're only really talking about, from the respondents' perspective, the U.S.-based domestic entities. So this really thinks the majority went beyond the question presented and potentially spoke on an issue that will raise concerns in the future. Second bedrock principle, that of corporate separation. Again, Justice Breyer notes this gives way in certain circumstances. This is not quite as bedrock as the majority might want it to be. Obviously there are doctrines for veil piercing or alter egos or nominally separate businesses that underlie a lot of corporate litigation. First Amendment precedents leave no doubt that corporate formalities have very little to say about the First Amendment issue before us. In fact, it's kind of interesting in this point because, as Justice Breyer notes, this kind of corporate formality issue has never really played into the First Amendment before. In fact, the most recent cases we've seen a functional analysis take place when we're looking at speech. Who is the person perceived to be speaking? What is the perceived understanding of their words or the message? Here, it really, the majority just kind of ignores that entirely and goes to this very kind of rote and formalistic approach that is really at odds with past precedent. And then finally, Justice Breyer goes in and rebuts the distinction drawn by the majority between the present opinion and the 2013 case. He argues this is not a choice issue. Both U.S. and foreign governments often require respondents to work through foreign affiliates. Justice Kavanaugh doesn't really address that. And notes that, well, the respondents here have a choice whether they could speak through foreign entities, and that's the end of it. But the record does reflect that both U.S. and foreign governments sometimes require the respondents to act in a certain way, including to partner with local affiliates. And even if this was a voluntary or a choice that the respondents could make, we still have a First Amendment problem. Justice Breyer points out, Woolley versus Maynard. That was a case where we're talking about speech on a license plate. No one in that case would have accepted the argument that there's no First Amendment problem just because a driver could choose whether to have a car or not. So we still have this First Amendment problem that goes largely unaddressed. As Casey noted earlier, the majority appears to be afraid of disrupting policy, which the government never really attempts to justify, indeed odd in a compelled speech case, and instead seems to shy away from writing a hard line-drawing opinion that would require some more factual analysis. And as Justice Breyer points out, the real party that suffers is the marketplace of ideas.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.